Hello, welcome to Just Africa. We are reaching you live from our studios at SOUQ News Television. I am Oyin Priye Krumale. Today, as the world marks the International Day of Criminal Justice, we turn the spotlight on Africa, where the quest for justice, good governance, and economic growth are deeply intertwined. The International Criminal Court, ICC, established under the Rome Statute, was envisioned as a beacon for global justice. Yet, its relationship with African countries has been complex, marked by debates over fairness, sovereignty, and accountability. Welcome to the program again. I'm Oyin Priye Krumale. As usual, the two gentlemen you know on this program. Good afternoon, good morning, good evening to you.
Welcome. Thank you very much, Oyin Priye Krumale.
Yes.
Welcome to Just Africa. I am Olumide Shukoya.
Yeah. So, on one hand, we will be looking at how the ICC, really conveyed itself or painted itself as giving the platform for everyone, whether be it in European countries, the Asian countries, the African countries, to serve both purposes and the potency of it. And if it has actually regulated the justice system in the global space, if it is not being controlled by one party, and how Africa as a continent would have benefited from it. But when I look at issues like this, I tend to go to General Obasanjo's administration and the Fourth Republic, where Bakassi Peninsula and Bakassi was ceded off to Cameroon. And I take a look at what actually happened during that dispensation and how Obasanjo, known for his no-nonsense disposition, being a former military head of state and a civilian head of state at that time, how he acquiesced and agreed to the terms of reference, whatever it was that was presented to him, and made Nigeria to give up that space, because I had conversed with some other persons who felt his actions. Because I knew after that action, scholars, a lot of Nigerians who are professional diplomats, international law experts, both criticized and others actually defended his actions. But probably today we may, whilst looking at this topic, throw it to our guest. He is also a legal expert as we, interrogate this conversation.
Today gives us a crucial reminder of the foundational role the robust justice system plays, not only in upholding human rights, but also in maintaining social order. Because whether we like it or not, a good justice system will make the economy thrive. It will restore some form of public confidence among its citizens. So exactly. I'm looking forward to our guest. I'm looking forward to diving deep into this topic and, rubbing minds, basically, and having an impactful discussion.
Great. On that note, beyond international justice, Africa grapples with internal, legal, and institutional bottlenecks that slow down economic development. Weak enforcement of contracts, corruption in judicial systems, and regulatory uncertainties. How do we align Africa's legal and regulatory frameworks to unlock its growth potential? And what role does international justice play in shaping development outcomes for the continent? To unpack these questions, we will be joined by a highly accomplished guest, Chimezie Owama, whose multidisciplinary expertise uniquely positions him to speak to these issues. We're going to break. When we return, we'll have our guest join us. Do stay with us.
International Day of Criminal Justice. Wherever there is power, there is potential for abuse, and wherever injustice goes unchecked, humanity suffers. But justice, when pursued boldly and fairly, becomes the line between chaos and accountability. Every year on July 17, the world marks the International Day of Criminal Justice, also known as the World Day for International Justice. This date commemorates the adoption of the Rome Statute in 1998, the foundational treaty that led to the establishment of the International Criminal Court based in The Hague. This day is more than a legal milestone. It is a powerful reminder of the global fight against impunity. It reaffirms the international community's commitment to justice for victims of genocide, war crimes, crimes against humanity, and the crime of aggression. Observed worldwide, this day promotes awareness of the ICC's role in upholding accountability and supporting victims of mass atrocities. It also highlights the importance of rule of law in global peace and security, particularly at a time when justice is threatened by rising conflict, political instability, and human rights violations. The ICC continues to be a beacon of hope for survivors, a permanent court where no rank or position shields individuals from prosecution. Though not without challenges, the court symbolizes a growing international resolve that grave crimes must never go unanswered. As nations and civil societies reflect on this day, the call is clear: justice matters. Upholding it in courtrooms, policy rooms, and public discourse remains key to protecting human dignity and securing a more just and peaceful world. Moyosore Adebi, SOUQ News TV.
Welcome back. Many thanks for joining us on the program. Now, joining us on the program is Chimezie Onwuama, LLB, BL, and MSc. He stands as a truly multidisciplinary legal professional. He combines profound expertise in legal services, tax, regulatory, and corporate compliance domain with a sophisticated understanding of finance and strategic business development. His extensive legal practice has given him an unparalleled grasp of Africa's intricate regulatory frameworks and compliance requirements, making him an invaluable voice in analyzing how justice system impacts business and development across the continent of Africa. Good afternoon to you, should I say, Barrister Chimezie, and welcome to Just Africa.
Good afternoon. Good afternoon. Thank you for having me.
Welcome. Many thanks for joining us on the program. Now, first of all, I know our dealings, we are going to be looking at a variety of conversation with regards to our topic on international justice system. We'll look at its impact in business, economy, and development across the African continent. And we'll also look at the reason why the bilateral or the global institution, the ICC, International Criminal Court, was created, and if on its own operations have done justice to the continent of Africa by way of the way it handles cases that relate to African countries. Does it demarcate or does it upscale the acceptability of the African nations across the globe? Welcome once again to the program.
Thank you very much. So we have to look back. Why was the International Criminal Court established? It was as a result of the Holocaust, just a direct consequence of the Holocaust. And the message at that point was this should not happen again. There should be a mechanism, an infrastructure for holding leaders and sovereign nations, leaders, and other responsible parties to account. There must be something to make them But the problem of now, the question we'll have to ask: to what extent has the International Criminal Court actually yielded fruit? How what extent has their actions yielded fruit? How enforceable are their efforts? You have some leaders now that yes, there have been some convictions. You have the some of the Serbian cases, the issues, with Milosevic and some other people who were actually convicted. But to what extent have their actions become a deterrent to illegal actions, unlawful actions by sovereign entities? So, well, I would say yes, to an extent they have worked, they have been effective. But do they demarket? No, I don't think they demarket. In Africa, I don't think they've really had as much effect as they could have, because you have issues like the Sudan, you have issues like some other states in West Africa, where you had prevalent human rights abuses, you have genocide in some countries, and as much as they have tried, they are limited. The International Criminal Court is significantly limited in terms of jurisdiction and enforceability.
Okay.
I think they do. I would say yes, they do. They demarket to an extent, yes, but to an extent, no. Because if there is no infrastructure for holding people leaders to accountable, then how do you? That means it will affect investor confidence. People will not feel like they can come and invest profitably within Africa.
Thank you very much, Chimezie. Now, I want to ask this question. If the International Criminal Court was set up for the purpose of upholding international justice and to also hold to account leaders in their own domain of governance who must have, abused the rights, the fundamental human rights of the citizens of their countries or their country people by putting them through hardship or putting them through circumstances that are contrary to global standards. We're still pointing the light in African countries. Why do you think anyone or if someone was to take any nation to court, take them to the ICC, would they entertain cases coming, apart from looking at specific leaders that carried out human rights abuse activities? Can any state take, for example, Burkina Faso or Niger Republic or any other country, most of these African countries within the Sahel, the recently created Sahel states, for taking over the powers of government, disrupting democratic governance and bringing in the barrel of the gun to usurp power? If they were to be taken to the ICC, would their cases be entertained or dismissed? Because we are in the dispensation where democracy seems to be the standard of leadership, both globally and in regional sense. Even these countries in the African Union subscribe to that. What's your perspective on that argument?
I would say now, when the context you gave now relates to constitutions of countries, of nations. So now you ask yourself, are they attacking their constitution? If it's something that if it attacks the constitution of the state or the country, then it is a domestic matter. The ICC does not have jurisdiction on those matters. But the ICC has jurisdiction where it's based on the Committee of Nations. There is the relationship between when there is something that happens between two nations. So if I come and I kill one citizen of another nation, we say, oh, we are going to kill all the Ghanaians in Nigeria. That is where the ICC has jurisdiction. But if I kill Nigerians within Nigeria, it is typically a Nigerian matter, except now it is a case of genocide. except genocide, ethnic cleansing, or other similar things. Like now, let's say something like the Civil War. Let's assume during the Civil War, Nigeria decided to start killing some people. There are some massacres. Now, in those were situations that would ordinarily qualify for the International Criminal Court. But when you say taking power, those are offenses against the constitution of the state. And states and the countries have the inherent jurisdiction to attack that. That is where you have, so if I attack the constitution of Nigeria, then that's what you call treason. So the state has full jurisdiction over it. So even if if I'm the president today, the moment I leave, the state can actually move against me in that regard. But however, if it's so there are limitations to the jurisdiction of the International Criminal Court. Now, if you look at the Rome Statute, which confers the ICC with jurisdiction, which creates the ICC and creates and converts it to jurisdiction, you will have to know, you will understand that it has its jurisdiction is limited to war crimes, crimes against humanity, genocide, and crimes of aggression. It doesn't enter crimes like treason. So those things are that's the core jurisdiction of the ICC. But so if an issue does not affect that, so if I decided that okay, I'm going to take over Nigeria, power in Nigeria, and in the process I'm going to kill all the Hausa people, then the ICC has jurisdiction. But if I say I'm just taking over the government and I'm just doing one or two, then there's no issue. But if there is a crime of external aggression, so if there is a crime of aggression against another country, yes, you can now call in the ICC. That's when the ICC qualifies to intervene in the matter. However, it is important to note that for the ICC to have jurisdiction, the state must actually be a signatory to the Rome Statute. It is important. If the state is not a signatory to the Rome Statute, the ICC does not have jurisdiction. But however, if the person is now enters a state that is within, if the person is now a resident of a state, or even if they are passing through a state that is a signatory to the Rome Statute, then they can be arrested and brought before the ICC.
Thank you very much, Chimeze. So let me come in here. What role should international bodies like the African Union, the European Union play in enforcing international criminal justice?
That is a tough question. Thank you for this question. Now, it begs the question, but your question begs another question. To what extent can supranational bodies intervene in national sovereignty? To what extent can they interfere with the sovereignty of a nation? So there's a balancing act that has to be managed. You have the ECOWAS court, which is supposed to manage human rights situations in West African countries. But now you have a judgment from the ECOWAS court. How do you enforce it in Nigeria? If you get a judgment against the Federal Republic of Nigeria, how do you enforce it in Nigeria? So most of the judgments are gotten, they are declaratory, they are advisory, they cannot be enforced. They are difficult to enforce. Except we have strong enforcement mechanisms. I dare say we can only do the supranational agencies can only do very little. So in West Africa, we have infrastructure for that, but because states have not really supported the ECOWAS courts, we've not gotten a lot of progress in West Africa and Africa as a whole. However, in the ICC, when you look at the ICC, in the actually UN countries outside in Europe and the EU courts and other courts, you will see that there has been a lot of judgments are enforceable. In fact, they are adopted. You have to when you get the judgment, you have to now register the judgment and then enforce it. When it's registered, it can be enforced. So in Europe, it's registered, it's enforced, but in Africa, it is still we have problems, and that's because primarily we have imperial leaders. Our leaders are we don't we while we say we have democratic institutions, we have more or less absolute leaders operating in West Africa. We don't have truly democratic institutions, and in order for you to have effective international justice, you must have strong enforcement infrastructure, strong enforcement within the state and outside the state. And countries that do not comply should be held, countries and leaders that do not comply with judgments should be held accountable. And there should be something to point, there should be strong sanctions that will compel enforcement, compel good behavior. Right now, it's just moral suasion. You call a country, you say, oh, Nigeria, don't do this. Nigeria, we have held you liable for, like for instance, the Ken Sariwa situation. There were sanctions against Nigeria. But to what extent are those sanctions effective in preventing such conduct in the future? You know, the jury is still out on that. But that said, we still have a long way. We have a long way to go in West Africa as a whole and Africa as a whole.
All right, Chimeze. So let me ask another questions in furtherance to this. How can international justice system address allegations of war crimes against by powerful nations like the United States, Russia, and even Israel?
There have been cases like the My Lai cases, the one that happened in Vietnam, the massacres. Countries, not countries, the parties were actually held. So they were actually the parties that engaged in the war crimes. They are held to account. The U.S. released their soldiers. They held them. They were held to account, and they were imprisoned. Some of them that were found guilty were imprisoned, although some were acquitted, some were discharged due to lack of evidence. So there have been when countries comply, the international bodies are actually very, very effective. There have been several cases. Of course, we know Slobodan Milosevic. He was in prison. He died in prison. We have some other world leaders who were held accountable. Once they left office, they were arrested and held accountable. They were brought before the ICC and they were held accountable. So yes, they are very effective. The ICC they have been effective in aiding international justice. So you know that if you're doing rubbish, if you're engaging in war crimes, you're just levying unlawful wars, with that wars of conquest, wars of imperial expansion. You know that if you mess up and you are held and you are caught, you will be held to account. You will be held to account. You will go to prison. And now you have to understand. Well, the US is still the US for countries like the US is a challenge because they are strong and they can determine not to. I don't think the US is actually a signatory to the Rome Statute. I'm not sure, but I'll have to check now. But I'm not sure the US is a signatory to the ICC. No, but it's not. The US is not a state party. Yes, I just confirmed, but they are not a state party. Although they support, but they are not a state party. So when you sign and you are a state party, then you are compelled to comply.
Okay. All right. Thank you very much, Barrister Chimeze. If you can hear me now, I want to bring you back to Africa. And this time, two of the very significant countries that you mentioned within the continent, I want to bring them back to the fore of our conversation. And that is Sudan and Kenya. They are under the watchful eyes of the International Criminal Court. There is political instability in Kenya. Also, there is political instability in Sudan. And multinational enterprises, multinational corporations actually looked at these indices before they consider it as a very good, productive, and with profit potential designations before they establish their companies and organizations, which in other words would be a win-win for the MNCs and these countries. For the MNCs, they will be, these countries will provide a good location for them to establish their business. And then probably they'll be giving tax waivers and all of that. But for the countries themselves, they should be getting transportation, infrastructure development, the transfer of technology and all of that. But it seems that this is absent from these two African countries that we talk about. Not completely absent, but to a certain extent, there is capital flight because of the level of political instability and probably the role or the assessment of the ICC in that region. Do you think the ICC is balancing justice system across continents? Or maybe that there is a lopsided perception? What's your take on it?
Your question is like a Gatling gun. But the ICC doesn't have, you have to understand, there is a balancing act, there is state sovereignty. You cannot interfere in the affairs of a state. But a state can do whatever it wants within its borders. A sovereign cannot be brought before another court. However, a person, a citizen, who is acting contrary to, now provided the state is a signature of the Rome Statute, or the state offends a signatory, a citizen that is a signatory of the, that is a name, like now, as I gave you an example before, if Sudan is not a signatory to the Rome Statute, the ICC, I think Sudan is in the ICC. I think Sudan is in the ICC. But now Sudan, the fight in Sudan is a secessionist battle. They are trying to have South Sudan. It's a question of secession. So the situation of the Janjaweed, where the Janjaweed are used to attack people, is a situation where, yes, you can say it's a war crime. It's a crime of ethnic cleansing. And secondly, so countries like Sudan is not a signatory to the ICC. So you have issues. Although the ICC can investigate, the ICC investigated the Darfur crisis and the genocide in Darfur, but it could not really take action. So unless the state now indicts its own people, unless the state indicts its own people and then sends them, or maybe the person now kills, let's say they kill a citizen of a state party. If maybe a country like let's say the UK now, that is a state party of the ICC, if a state party citizen is killed in Sudan, then the party they can rendition what they typically do, where it works, they can rendition the indicted, the person, that the offender, they rendition him to a state party, and then they can charge him before the ICC. But only a person. The ICC typically does not move against states; it moves against persons. Now, to what extent can they intervene when the person?
Okay, I think we have some form of technical challenge there with Barrister Chimeze. Well, I'm glad he's bringing to light some of these conversations. And where I wanted to take him to after answering those questions was to bring him face to face with some of the happenings between African countries, Nigeria and South Africa. What happened at the time where Nigerians were being, attacked in South Africa with not just Nigerians alone. There are other countries that are being attacked, African countries that were being attacked, but the Nigerians were at the forefront because of population in South Africa. And even till now, when we had the Ghanaian who came here and spoke in Just Africa, he also mentioned how Africans will be looking at themselves. So in cases where Nigerians are being attacked in foreign countries like South Africa or in Cameroon or in some other Africans, there was the ICC, even without prosecution, even without the Nigerian government moving the hand of the ICC. Yeah, can they stand up to that? Those are some of the questions I'm going to look at, and also look at the Olusegun Obasanjo's case I referenced in the Bakassi Peninsula and how the Cameroonians took it over. How, if he had hesitated, or probably there's a government tomorrow in Nigeria that's more of give Nigeria. We have a foreign diplomacy, like our foreign policy now changes, where we now start exhibiting a strong power or hard power to make decisions with regards to our foreign policy, and not soft power or diplomatic power making, and says, okay, the previous government handed over Bakassi Peninsula to you, but I don't think it rightly belongs to you. I would like to take it back, and it starts that. What kind of position, if that's a case for the ICC to come in? We heard that Barrister Chimeze is back on the line. Many thanks for joining us once again, Barrister Chimeze, if you can hear me clearly.
Yes, I can hear you perfectly.
Yes, please, I want to take our conversation to the next level, where we have dealings between African countries. I was having a conversation with my colleague about referencing cases in South Africa recently, not too long, where Nigerians were being the target of a social disorder in South Africa. Nigerians were some of the targets. Some other African countries, their citizens were some of the targets too, and some Nigerians back at home wanted to respond, but the Nigerian government intervened not to. So in such cases, without the Nigerian government going to the ICC, can the ICC stand up to that fact by prosecuting the South African government, probably for not intervening on time? That's one question on one hand. But on the other hand, I want to take you back to the inception of the fourth regime, where Obasanjo, former President Olusegun Obasanjo, came in as as a civilian president in 1999, from 1999 to 2007. And before his administration elapsed, Bakassi Peninsula had been ceded to Cameroon. If we had another government come up in Nigeria today and says, I want the Bakassi Peninsula back, and confronts the Cameroonian authorities, how do you think that will go? And does that mean the ICC is going to hold back Nigeria and make it to subject itself to the former agreements that the previous administration had?
Okay, so first, I think you made a mistake when you said ICC. There is the ICC and there is the ICJ. They are two different courts.
ICC and what?
ICJ, there is the International Court of Justice, and there is the International Criminal Court. So the International Criminal Court focuses on war crimes, genocide, crimes of external aggression. So that's part of public international law. Now, the ICJ is it's more like an arbitral body. It handles disputes within states, territorial disputes. So a state can submit itself. The two states can say, look, we're having a problem. Let's find a neutral third party that will arbitrate. So the ICJ looks at it, looks at all the facts, looks at all the information, and says, look, based on historical and legal precedents, this is the situation. So by virtue of, and in the process of submitting yourself, you must also undertake to comply with the order. Now, so in Nigeria now, there was the Green Tree Agreement. The Green Tree Agreement was signed during the Bakassi conflict. They signed it and said, look, we undertake to comply with. It was done by the ICJ, under the ICJ, and they said we are undertaking to comply. So whatever happens, we will comply, and if we do not comply, sanction us. So now what has happened is when it was determined that the ICJ ruled that Bakassi belongs to Cameroon as opposed to Nigeria, Nigeria complied. If they are now in when you're looking at when you want foreign investment, if you're looking at foreign investment and you decide, yes, truly, Nigerian tomorrow, a fellow that doesn't know Joseph can wake up tomorrow and say, we are going to take Bakassi by right of conquest, which is what is happening in the Ukraine. The Russia says, oh, this part is our own, or in Gaza, in Gaza now, the Gaza Strip, the UK is there. Israel says, well, the Gaza Strip belongs to us. The Palestine says it belongs to us, so they start fighting over it. It can happen. But when that happens, it's first of all you have a lot of sanctions against the country. So the public international law favors the implementation of moral suasion, amicable resolution, and at the worst, they now use sanctions. Now, as a last line of offense, like what happened in Iraq and Iran, you can have a state force, another state party can go in and use force to compel the offending party to comply with the ruling. So if Nigeria decided to go to war against Cameroon in order to take over take back the Bakassi Peninsula, you might just find that the UK or an international force just lands and come and start, they can land and just keep the peace in that environment, chase Nigeria away. I say, look, restore the situation and enforce the ruling of the ICJ. It is possible to an extent, but will it happen? I don't think many countries have tested it apart from Russia, and Russia has tested it, but you can see the amount of sanctions against Russia. You see the amount of sanctions that Russia is undergoing. It has literally almost crippled the economy. And that when Germany tried that, they saw it was a terrible season for them. So, and Iraq tried it, and it also there was a lot of problems for them. Iraq invaded Iran, and it led to a lot of problems. So it's not economically, except the cost of resisting the ICJ's ruling is usually much higher than the benefits if any action like confer on the offending country.
All right, thank you very much, Barrister Chimezie. So I would like to ask, are digital courts, ADR, I beg your pardon, alternative dispute resolutions, and mobile court, are they making a difference? Are they actually making an impact in our justice system?
Yes, I can say that without qualification. I remember now you can sit down in your house. You can sit down in your house and choose Zoom. A person can, before, if you had a case and your witness was in the UK, you had to buy a flight. The person will come down to Nigeria. God helping you, the day the person lands in court, the court does not sit. And the court might just adjourn to like 3 months. It was a lot of waste. It was a terrible environment then. But now, you can have a situation where you are in court on Zoom. You can run your trial via Zoom. It has helped. ADR is wonderful. ADR has really, even the inclusion of small claims courts, citizens mediation centers, multi-door courthouse. It has significantly reduced the caseload on the court. Although there is still much more that can be done, But there is a lot of it has had a positive impact. Although, however, I think the problem we have in Nigeria is resistance by people within the court structure. So you have situations where, like for instance, Lagos State, we have two we have two portals. Lagos Commis, which handles the magistrates courts, why and you now have Lagos Judiciary, which handles the High Court. Now, Lagos Commis is seamless. You can run a lot of things easily. It moves very quickly. But the Lagos Judiciary portal is it has too many. What you first go and prepare when you prepare the document, you take it to them. You have to scan it. When you finish scanning it, you scan it into the system. You now have to take it somewhere for somebody to sign on it. So until we embrace full digitalization and full automation, I think we will have a problem. But a lot, that influence of the politics of it, they don't want people to lose their jobs. All those kind of considerations is preventing the full implementation of these initiatives. But it is helping. I dare say it is helping. It has reduced a lot of stress on many of us. You can sit down in your house and run a trial digitally. You can, in fact, during shortly after COVID, I had a case where the magistrate was in her car. She sat down in her car, handled all of us from our various homes. We did our work. We finished our cases. We didn't need to enter the roads, stress yourself, come to the court. It's a lot of but there's still a lot that can be done. There can be, I think, we can still embrace digital case management. We can embrace this better. They can better implement digital case management. Better implement digital ADR. I think with AI, if AI is fully implemented, a person can, if some minor cases can be addressed, like small claims, you can just put in your case. They will evaluate your case. They want a case evaluation. The judge knows what to do. Quickly, cases can be disposed of. The problem we are having is that a lot of our judiciary are still focusing on old ways of doing things. They are not really adopting new practices. They are slow to adopt new practices. But because it's a big problem. It's a big problem in Nigeria. People are afraid of adopting new practices, and that resistance to change is affecting the full implementation of digital justice.
Chimeze, so one last question. How can African Union, ECOWAS, how can they help push for a continent-wide judicial reforms?
They cannot. We can only do it human. Now, you have to understand, there is a limit to which they can interfere in state affairs. So yes, they can train. What they typically do is run trainings. They train, they educate. So judges go for trainings, judges go for secondments. They learn. But to what extent? How many? When you have over 5,000 judges in Nigeria alone, that's not counting the cadis and not counting the customary courts and the other inferior courts. How many can you choose? I think the emphasis will be placed more on the national judicial councils and state judicial service commissions. They should implement better training, implement better sensitization and education of the judges and magistrates. They should, I think there needs to be more better structures and systems put in place to ensure that justice is not only done, it is seen to be done. So the African Union can only interfere to a very minor extent. They can only interfere morally, they can only educate, they can say, oh, don't do this. They are like a big brother, but to a large extent, they are a toothless bulldog. They don't have teeth. They have back, but they don't have teeth. In this scenario, they will say, okay, we will enforce one or two trade sanctions, or we will not allow you We will not hear you when you have they can't if the financial judgments can be enforced, yes, against state parties. But if it's a non-financial judgment, how do you enforce it? Are you going to, unless you can bring an army that will land in that country, how do you enforce it? So if I wanted to be sincere, I would say that they are limited. They are significantly limited from effectiveness. Their effectiveness is limited, but they have a moral power. They have sanctions. They have the power of sanctions behind them, and if there is contempt of their rulings, they can actually take actions against defaulting countries.
Thank you very much, Barrister Chimeze. Thank you so much. Uh, before we go on a break, I would like you to attend to this question, most especially because of you've spoken extensively that the African Union, like a toothless bulldog, they can bark but they cannot bite. They don't have those fangs to actually enforce. But what about the ECOWAS court? What about the ECOWAS court in the sense that continental agreement and treaties like the African Continental Free Trade Agreement was supposed to bind all countries together that append their signatures to the existence of that continental document. The ECOWAS court is also going to carry its own legal framework to govern the economic activities within the West African region. And these are only documents that can be enforced in order to allow the objective of this continental and regional bloc agreements that were formed to manifest in terms of trade and investment among member states. Legal frameworks from each of these African countries like Botswana, DR Congo, Nigeria, and Ghana, how strong are they to uphold their legal system to match up with the agreement and the expectation of like the ECOWAS and the African Union so that the African Continental Free Trade Area Agreement can work properly?
I think the AFCTA, the idea of the AFCTA is facilitation of free trade. Now, if it relies on cooperation among member states, so if we decide that you are going to prevent free trade to your country, of course, other countries will say, okay, you don't want free trade to pass through your country. No wahala. If you are going to levy tariff, we retaliate by levying our own tariffs. So, but you have to understand, ECOWAS court is only for ECOWAS countries. If you're looking at something like Botswana is South Africa because it's not a part of the ECOWAS bloc. But every state is under obligation. Every member state that has signed and ratified the AFCTA treaty. If you have signed, you ratified it, and you have adopted it as part of your legislation, your corpus of legislation, you are meant to create structures and systems to ensure that it is effectively implemented. So technically, and now if you fail along the line, of course there are failures here and there, but that's why you have the monitoring bodies. You have monitoring agencies who will investigate. But would they force anybody? Would they say, oh, Nigeria, you are placing a tariff? No, like Nigeria can block its borders and say, look, we want to protect our automobile market. We want to develop it. So we are going to restrict importation, free trade of automobiles from Benin Republic. To what those things have to be, it relies on cooperation. They can say, look, Benin Republic, for 3 months, please let's restrict this while we work on our own system. But however, if you now decide, oh, I'm going to block the border and we're not going to allow anybody, then other countries will say, okay, we will block our borders to you too. You can't export your own goods. Let us see who Let us see who will get tired first. So, because countries rely on international cooperation to survive, that's in terms of public international law, they rely on international cooperation. They need to trade. So that there is no, it doesn't make sense. It makes no sense to go against these international treaties and protocols. They have to work together with other states, help them achieve while they achieve mutually beneficial outcomes. Now, can the courts force anybody? I don't, to an extent, yes, they can. They can to an extent. They can say if a tariff is levied, a member state can go and complain and say, look, Nigeria has levied a tariff on our products. And instead of them retaliating with another tariff, they can complain and say, oh, look, this tariff is affecting our business. And in such a situation, the courts can wade into the matter and say, look, Nigeria, you're a member of this of this treaty, you cannot levy, you can't levy a tariff on this product. They can't do that. But mostly they can only interfere in an arbitral capacity in order to resolve the dispute. But why would you waste time going to court when you can retaliate with your own tariff? You know, you can retaliate with your own tariff, and because if you get a judgment, all these judgments, international judgments have to be enforced. Remember what I said, international judgments have to be enforced by national entities. So if a judgment is gotten against Federal Republic of Nigeria, which judge is going to enforce it in Nigeria? Are you going to enforce a judgment against your own country? So those are questions. Those are the problems we have with private international law, public international law. They can't enforcement of judgments, no matter how beautiful the judgment is. Once it cannot be enforced, what do you get? What do you gain? Like if you remember, I think the Abiola family got a judgment against Nigeria at the ICJ. No, it wasn't the ICJ, it was in the US. Is it enforceable? So enforceability is the key consideration in any issue, any international law issue. However, that said, if we consider the economic benefits of cooperation and international community, it is better. I believe it's better for states to work together. But can they be forced? Can they be coerced or compelled? They don't. National courts have the coercive power of contempt. So if I make a judgment if a judge in Nigeria makes a judgment against you and you don't comply with the judgment, they can.
All right, Barrister Chimeze. Thank you so much, Barrister Chimeze. I wish we had all day to continue this conversation, but I want to thank you so much for your time with us today on Just Africa, and hopefully we'll have you some other time, because what we have to discuss is somewhat inexhaustible, so that we can have that conversation subsequently and have a very, very good trade relations between Africa and how the government can intervene to make the rough edges straight. Thank you so much for your time with us today on Just Africa.
You're very welcome.
Thank you. So the AFCTA, the legal systems of independent countries have their own specific roles to play to make it a viable thing to do. Africa has lots of work to make trade function.
Yes, it does.
Yeah, and it's a good place for us to draw the curtain of the program today. Many thanks for joining us. Now do well to follow us on all our social media platforms at SOUQ News TV. I am Oyin Priye Kurumade, and I say thanks for watching until I come your way again tomorrow. Do have yourself a splendid day ahead.
And I'm Olumide Shokoya. Don't forget to follow us on all our social media platforms at SOUQ News TV. Have a lovely yourself day.